Welcome to Constitutional Law. In this series of videos, we will cover all of the major testable issues in con law. Just about every expert who has ventured an opinion agrees that con law is the easiest subject on the multi-state bar examination. On the MBE, one of the four picks has to be correct, and it's difficult for the examiners to play very complicated word games on con law. If you haven't done a lot of MBE practice on constitutional law, I encourage you to get into it. It's an area that at first will be a little confusing, but as you work through some of the questions, I think you'll agree that this material is a little easier on the multi-state than just about any of the other topics. This series of videos will track the National Conference of Bar Examiners outline directly. After this introduction, we will move on to a consideration of judicial review. After that, we will examine separation of powers. Next, we will consider federalism, and then we'll have a couple of videos that go into individual rights. That's the way the material is organized, and that's the way the material is tested. On the multi-state, about half of the questions from con law deal with individual rights, and the other half deals with everything else on the outline. So it's easy to get bogged down looking at tiny little obscure details of constitutional law that hardly ever end up being tested. So together we will work our way through this material, and I think you'll see this is fairly well organized, fairly sensible stuff, even if it tends to be a little counterintuitive around the edges. But rest assured, there's a lot less material in constitutional law than there is in torts or contracts or real property. And if you take a step back and just look at the numbers, there are more questions on negligence on the multi-state than there are about individual rights under the Constitution. So, let me continue by offering an idea about how to think about constitutional law. This has a little bit more to do with the essays than it does on the multi-state. As I've indicated, the multi-state bar exam is fairly straightforward with regard to constitutional law. But the essays, both on the MEE and across the country in other state exams, those tend to be a little bit more complicated. And the reason they're more complicated is because often the examiners will require us to come up with the various constitutional theories as opposed to just spoon-feeding them to us. So having a well-organized way of thinking about constitutional law can be enormously helpful on the essays. So let's get right into it. Here's how to think about constitutional law, particularly for essay purposes. The first thing that you ought to do is carefully examine and list all of the plaintiff's injuries. By the way, this is the same first step that we would take in a torts question. But in con law, sometimes the plaintiff suffers injuries that are a little bit more subtle. So, step one, identify the plaintiff's injury. Now, step two, consider the status of the plaintiff. Because in constitutional law, depending on who the plaintiff is, certain threshold constitutional law issues arise. So, in a con law essay question, if the plaintiff is a private party, you have to show up front that the plaintiff has standing. And you also have to discuss right up front ripeness and mootness. And in the substantive videos, I'll give you some fairly clear ideas about what those issues really are. But suffice it to say for the purposes of this video, that the first step is we identify the plaintiff's constitutional injuries. Why is the plaintiff angry? Then we examine the plaintiff. If the plaintiff is a private party, we've got to show standing, and we need to discuss ripeness and mootness. On the other hand, if the plaintiff is a government, as opposed to being a private party, we have to consider intergovernmental immunities. That's a small issue. It is infrequently tested. Next, we consider who the defendant is. Certain issues are triggered just by the status of the parties. If the defendant is a private party, we have to consider state action. And we'll go into state action in a little bit of detail in a few moments in the next video. Then, if we've got a defendant that is a state or local government, we have to consider first the Interstate Privileges and Immunities Clause, next the Commerce Clause, probably the most heavily tested issue in this area, express and implied preemption, and police power. those are the issues we consider if the defendant is a state or local government. Again, interstate privileges and immunities, the Commerce Clause, express or implied preemption, and then the police power. Suffice it to say that the police power is the most common source of state political power. Now, suppose the defendant is the federal government. If the defendant is the federal government, then we have to consider the executive powers, again, domestic and foreign, and we have to consider the judicial powers. And remember that, broadly speaking, we're dealing here with Article 3 courts, which are the general federal courts, and Article 1 courts, which are the more specialized courts under the federal umbrella, including particularly the bankruptcy courts. Next, we consider legislative powers. So again, if we're dealing with the federal government as the defendant, then we consider all three of the different branches of government and their various powers. With regard to legislative powers, here again we deal with interstate commerce and the postal authority. Now let me pause for a moment to consider one of the most important little distinctions on the Commerce Clause. Let's keep in mind that the Commerce Clause is a source of federal power. The dormant Commerce Clause is what we refer to when we are dealing with state laws that impact commerce. And we'll get to both the federal and the state commerce issues within the body of these videos. Next, under Congressional Powers, we consider the taxing and spending authority, the power over foreign affairs and aliens, the necessary and proper power, and the enabling clauses of the 13th, 14th, and 15th Amendments. All right, well, that's all we need to do to set up a constitutional law essay. Identify the plaintiff's injury, and then consider the identity of the plaintiff and the identity of the defendant, because a lot of threshold issues arise based on who the parties are. Then, finally, we get to the plaintiff's theory of liability, which will be based on various rights guaranteed under the Constitution. And here, what we are mostly worried about are issues arising out of the First Amendment, primarily freedom of speech, but also freedom of religion, and then the due process clause of the Fifth Amendment as applies to the federal government, and the 14th Amendment as it applies to the states. With regard to due process, we're concerned about procedural and substantive due process, and realize that the Fifth Amendment takings issue, a topic which has had a lot of new life breathed into it just during the course of my legal career, then we can consider the Fifth Amendment taking issue. That's part of the area of law where constitutional law and real property rub up against one another. Then, the last big constitutional right, which is being trampled continually, according to plaintiffs both in real life and on bar exam questions, is the Equal Protection Clause of the 14th Amendment. And here again, realize that the Fifth Amendment applies equal protection principles against the federal government. The 14th Amendment applies to the states. Here, we have to determine which standard of review will be applied to the situation, either strict scrutiny, intermediate scrutiny, or rational basis, and then we carefully judge the law at issue with the standard of review that applies. Finally, at the end of an essay, we reach a conclusion. Who wins? Does the plaintiff win, and if so, why and for what claims? And if the defendant wins, narrowly and specifically identify why it is that the defense prevails at trial. So, that wraps up a very brief summary of what we will do in these videos, and it includes an approach to thinking about constitutional law. In the following several substantive videos, we will consider all of the major issues in significantly more depth, but not exhaustive depth, and then we'll go on to do a series of 6 hypothetical questions. And these hypothetical questions, as you look back on them, will cover a very substantial portion of the outline. We will learn more about how this material is tested. Now, do as many multi-state questions as you can stomach and keep track of your mistakes. Where you learn substantive details based on practice, I encourage you to annotate the stripped-down outlines that I provide with this program. These outlines are reasonably complete, but they're not exhaustively detailed. The best way to learn the law is by doing a lot of practice, both for the multi-state and for the essays. As you learn additional details, annotate your outlines so that you can reinforce that knowledge and so you can have something to study when you have a few minutes that you want to spend on review and you don't really have enough time for practice. So, next, in the first substantive video, we will consider judicial review.